where we're at the present is the determination in the Ruth Morrissey case has had a chilling effect on laboratory scientists, in that if you're going to rule something as absolutely negative for any abnormal content or otherwise, then you have to have a standard of absolute confidence. And I don't think that there's anything in life we have absolute confidence in. So it was even, I give a legal opinion on something, and it is, well, if this goes our way, if this whatever, if that whatever. And then you have particular criteria that you're working to, and we'll work through those. The consequence was that, much to the annoyance of the media and general public who don't understand these things necessarily, the matter has been appealed to the Supreme Court, because we need legal certainty. If people are operating in a professional field, then may have consequences for their career, and also may have consequences on those whose cells they're making a determination on and about. Then you need to have a room for manoeuvre within that. There needs to be a level of humanity and human error allowed for in that, as well as the systems adjudicated. And so the state, in the first instance, have appealed it. They haven't appealed to the entirety of the case. They've merely appealed it on the basis of, we need clarification of what the law says. So it's absolutely the right thing to do that the state has appealed it. Naturally, that doesn't go down in certain media circles where it looks like we're putting this woman through endurance. In the meantime, Ruth Morrissey has received her payment. So it's not the facts of her case that are being, but it's the legal certainty that arises out of Mr. Justice Cavan-Cross's view. But the matter is going to the Supreme Court. So we are not in a place where absolute confidence is the standard of care expected until we're the other side of the Supreme Court. Okay, so we're in an arguable position at the moment. The law isn't confirmed, it isn't absolute yet. But I'm going to come through negligence simpliciter in the first place. Let's look at what is negligence, what needs to be proven for negligence to be the case, because then we can see why legal professionals consider that there has been a departure from the norm in the adjudication of negligence. So I want to bring you through that first of all. And then look at your role in the chain of causation, and then the absolute standard, and then look at that in fitness to practice consequences and professional liability consequences, which we can do, and potential consequences at the end. But everything is a may. So nothing is, this is the way it is now. Everything is, this is the way it may be adjudicated, and this is the way it may be viewed, because we're in this greyed area for the time being until we're the other side of the Supreme Court determination. This is not legal advice. This is a discussion on what may or may not be the case. I need to say that for the camera, since I'm going to be recorded and in there. I'm like you, I don't want to be disbarred or struck off or anything like that. Okay, so let's look at negligence. In the normal course of events, I expect to walk down Henry Street, Grafton Street, I might bump into people. That's just, we accept that that isn't assault, particularly if it's the week in the lead up to Christmas and there's a sale and it's packed. I'm not assaulting someone if I happen to bump into them. However, we have a general standard of care in how we are with each other in society, and that is that we don't go out of our way. So if I'm wearing a jacket with blades on it, well, then one would presume that I suddenly have a standard of care that I need to not bump into anyone. So there are assumptions that are just inherent in our coexistence with each other in society. Where negligence comes in is when we have above that a duty of care to a particular other party. So if I get in behind the wheel of a car, I have a duty of care to the passengers in my car and to other road users and anyone that might be out and about, because I am now in charge of a vehicle that could cause an accident, and there may be lifelong consequences or fatal consequences to that. So we end up with the three elements that if there is so the parties in the case are the plaintiff and defendant. The plaintiff is the party taking the case. They must prove certain elements when they go into court in order to be successful in their case. Those elements are, they have to prove a duty of care, that there's a relationship between the parties such that I owe you a duty of care. So if my child is in the playground and the person walking past, and they don't have a duty to run in and protect my child from falling off the slide. And the person, the care creche worker, or me as the parent, I have the duty of care towards protecting the children. So you've got, the first part of it is, there's a duty of care. There is a relationship between the parties such that the duty of care arises. Then they have to say, well, what was the standard? So there's an obligation between these two parties, but what standard are they to be held to? And then, did they cause it? So did they hold to that standard, or was there a causation element? So the three elements that we must do. The plaintiff always has to prove those elements. If the plaintiff, and they have support such as discovery motions, and that will assist them in getting information from the defendants. But they're the things that they must consider in order to bring home a case. Okay, so let's look at duty of care, the elements of duty of care. First of all, there has to be a relationship between the parties of some sort, that there is some level of engagement. I'm the driver of a car, you're the pedestrian. I am the doctor, you're my patient. You're the laboratory scientist in receipt of material for examination, and in that context you have a duty of your skills, your abilities, and what you apply when you look through a microscope. Obviously, you looking through a microscope and me looking through a microscope are two completely different planets, because I'm not going to see it. You know, I'm not going to see whatever, and you'll see and much more in that. So the first thing would be the relation. So there could be no duty of care attached to me in looking down a microscope, because I wouldn't be expected to see anything there. But you looking at it, it's a very different thing. The next element of it is there must be foreseeability about the damage. So there has to be that if I don't hold and do my skill, do my job, if I don't drive my car carefully and within the speed limit, then there is a consequence that may flow from that. If you don't do your job carefully, what is the consequence? Is it foreseeable? So some things are foreseeable, and there has to be, so if I pull into the side of the road and I throw open my door, have I looked for a cyclist? Because it's reasonable that maybe there was a cyclist, or there could have been a cyclist. So it's to put these expectations on us beyond what factually occurs. This notion that I anticipate what might happen if I don't do this to the best of my ability. Foreseeability alone it would be ridiculous. I mean, my mother foresees all sorts of happenings to my child. She'll fall off that, she'll break her leg if she does that, and whatever, and we've got to quell that. So foreseeability can be an exaggerated thing. So in order for foreseeability to really kick into place, we have to have this sense of a proximity of relationship. There has to be some sort of, so patient, doctor, parent, child, solicitor, client, that there has to be some sense of a socially accepted and normal relationship between the parties of some sort. And then we also need to consider, policy considerations. So why do we wear a seatbelt? If I'm in the car on my own, why do I wear a seatbelt? To protect myself. But, I hate seatbelts. I'm in the car on my own. But why is it the law? If I'm not wearing a seatbelt, the possibility of becoming quadriplegic as a consequence of an accident are multiplied versus not wearing a seatbelt, or versus wearing a seatbelt. And the higher the possibility of consequence, the higher the cost on the state. So it's a policy consideration as to why I would. So policy and finances and the distribution of the assets of the state are why we wear seatbelts when we're on our own in the car. Is to minimise the consequences and the staffing and all of the care and the price of the care. So we make policy considerations all the time as to whether something is unlawful, whether we need to bring in legislation around issues in order to minimise the consequences on the state. What is our standard of care? So the standard of care is, at what level do I have to operate? You know, if I'm driving a car and I'm spending my time driving at 5 kilometres an hour because I'm terrified of people walking off the pavement on their phones, which is a very real issue right now. If I do that, then I'm a danger in itself. This, you know, so we can't be. What is the reasonable standard? Well, the reasonable standard is we were travelling within the speed limit. The state takes the decision of speed limits, and as long as we're within that, then we're seen to be at a reasonable standard of care. As long as we're not on our phones, we're not, you know. So the standard is adjudicated, and it is proportionate and appropriate to the circumstances of the case. So the standard of care is considered about, well, what's the probability of this happening? Is it a high probability that if I'm, you know, speeding down a road at 100 kilometres an hour in a built-up area, I'm likely to kill someone? Yeah, that's probably pretty high. So we've got to put in a speed limit on that. And then we have, what's the gravity of the consequence? How serious is it? If in the standard, what are the consequences of this standard not being kept? Well, if you're in a situation where you're looking at a set of slides and the probability is that someone may die of cancer if you haven't spotted abnormal cells, well, that's a fairly serious, it's a fairly grave circumstance. So the standard needs to be considered very carefully around that. And then we look at the cost. What's the cost of prevention? So in the 1940s, a person walking in Bray happened to be hit by a boulder, a small boulder, that rolled down Bray Head, through a gap in a hedge, out and hit this person in the head. And in the context, they said, oh, there's duty of care from Bray District Council, they should have cemented Bray Head and stopped any boulders from. So you can see it's so ridiculous, the cost of that, and the probability of something like that ever happening again was very low. So it's a balancing act all of the time as to whether you find liability against the defendant in a case or not. So then we've got to look at also then the social utility. So the social utility in the Ruth Morrissey case is cervical screening, full stop. You know, as we stand at the moment, if you have people that are afraid to adjudicate a slide to be negative for abnormalities, then we will have every slide adjudicated to be non-negative. Every slide will be, because that would be the prudent thing to do. If I have to stand up and absolutely have absolute confidence that there is no abnormality and no other person would adjudicate an abnormality to be present in this slide, then I'm not going to take a chance. I'm going to say there's an abnormality in every slide. I'm going to, because why would I take that risk professionally and personally, and you know, and then possible consequences. So I suppose we come down to when we come to the idea of causation. What have we caused? What are we looking at? Is our action, does that cause what has occurred? You know, Ruth Morrissey had cancer. Nobody caused her cancer. They just didn't catch it on time. Now, the ultimate outcome may have been the same, even if it were, you know, that this lovely lady has less than 2 years to live. But it may have been that she was always going to go down this particular trajectory anyway, and nothing could have been done to stop that. However, naturally, the view of the court is, in the two smear tests of 2009 and 2012, the abnormal cells should have been picked up, and intervention could have happened earlier, and then maybe. So you can see causation is a little bit problematic in that we can't say she would never have contracted cancer, but then we get into probabilities and maybes, and that's where quantum of award is calculated and how quantum of award is calculated. So a plaintiff, when it comes to causation, a plaintiff has to establish in fact that the defendant was liable, that the defendant caused the consequence and the outcome. So the defendant caused that. And then there is causation in law. So if I work for Sky and I install satellites, so I have a Sky van that I drive around all day, you know, going from appointment to appointment, and I knock someone down at a pedestrian crossing, I am in fact driving that van. I was looking at my phone, having a fight with my boyfriend. You know, I am in fact responsible for the accident that occurred. However, in law, I am not liable. My employer is liable. So we have this is where we engage vicarious liability, and employers are liable for their employees, and that's who is sued. Now, I might be disciplined, I might end up being sacked from my job because I wasn't driving with due care and intention, and I'm in breach of the Road Traffic Act, and there may be other things like that. But liability in fact versus liability in law are two different things. And why that's relevant to you is you are, presumably, none of you own your own lab and are running it by yourself. You are employees of either a state facility or otherwise, and your employer should have protocols in place that you adhere to those protocols, you adhere to those systems. Yeah, we'll see between the two in the Morrissey case, the two different labs of Quest and MedLab, they had different review mechanisms in place, and both it still failed, but they had different mechanisms. But so if the staff member in those labs have done everything in accordance with the protocol of their employer, then it is the employer that is at fault. And then the employer may have an issue because there's departure from those protocols by that individual technician or that individual scientist. So this idea of this causation in fact and causation in law, and they're two different things. Okay, you all right with that? Right. So that is negligence simpliciter. Then we come into professional negligence, and that's the duty of care and the standard of care owed by professionals in a particular field. So how do we, in the original Bolam case was a case that went to the House of Lords to say, well, you know, the standard of care normally in everyday life is where we the reasonably prudent driver, the reasonably prudent individual, reasonably prudent, you know, construction builder, whoever. So do we have a reasonably prudent medical professional, legal professional? You know, do we have what is the standard of care in that? And in that, the House of Lords said, where you get a situation which involves the use of some special skill or competence, then the test whether this has been some negligence or not is not the test of the man on the Clapham omnibus, which is the person on the top of the bus, because he has not got that special skill. The test is the standard of ordinary skilled man exercising and professing to have that special skill. So it's a peer-to-peer review. So in professional negligence cases where it's a medical negligence matter in Ireland, the file of the patient is sent to the UK. Because it's such a small, we've such a small population of medical professionals, and they don't want people testifying against each other. So the files are always sent first to the UK, to doctors that know and consultants that know nobody, or allegedly, supposedly know nobody, and they will adjudicate on whether the procedures and the planned treatment for this patient followed along normal standards of people of a particular standard of skill, of competence, of experience, and so you have a peer-to-peer review of whether that was the appropriate statement or the appropriate procedure, the appropriate process or not. So it's a peer-to-peer comparison. Naturally, me looking at a slide would be a waste of time. You looking at a slide, you'll see many things that I won't see. So it has to be a peer-to-peer assessment. So that's the standard. That Bolam case is a very long time ago. However, it is the standard that has been employed in every medical negligence case in Ireland, and indeed in legal professional negligence cases. So it is a peer-to-peer standard. As we go on, the big case in Ireland has been Dunn versus the National Maternity Hospital, and that was really the first case where we started laying down our own tests rather than merely importing British tests, and so many of these cases settle. We don't get a lot of them actually going through where the Supreme Court get to say, well, yeah, we confirm this as the test. So the Dunn case has set the test in Ireland, And in that we say that, first of all, and I've written out the names so that you have them for your own reference. So the true test for establishing negligence in diagnosis or treatment on the part of a medical practitioner is whether he is proved to be guilty of such failure as no medical practitioner of equal specialist or general status and skill would be guilty of if acting in ordinary care. So it is looking at the competence of the individual compared with another individual of similar competencies and similar skills, similar standards. If that individual is brought in, would they have made the same decision? Would they have? And then we go, well, maybe they wouldn't have made the same decision. What else would they? Well, did they deviate from practice? Did they deviate from the normal protocols that would be applied in this? What are the normal standards? So in this, if the allegation of negligence against a medical practitioner is based on proof that he deviated from a general and approved practice, that will not establish negligence unless it's proved that the course he took was one which no medical practitioner of like specialist and skill would have followed had he taken the ordinary care. So you can even move slightly outside of the norm as long as someone else would have also stepped outside of that norm, and that it was a reasonable step to take. So that so you can look at a patient, a plaintiff looking at their medical notes can say, okay, well, they didn't do that. That's not normal. They went and they did something extra, or they didn't do. Well, maybe another practitioner would say that's okay. They stepped outside, but actually that was a reasonable thing for them to do. So in that, you've got to consider, well, what are the protocols, for you and what are the protocols in your lab? What induction, have you all been inducted into those protocols? Is there a piece of paper somewhere in HR that says you've been trained and inducted into why you're allowed it? What training, what ongoing CPD are you doing? Are you reading your journals, the journals for your particular profession? Are you keeping yourselves up to date? Are you, so that if you do deviate because you're going to try something or you're going to look at something quite slightly differently, you can justify it because you say, I read this medical journal. This is standard. This is why I do. So all the time you're equipping yourself to be the best professional you can be anyway, which we should be all doing anyway. But at the same time, then you're also equipping yourself with evidence to support why you've made the decision to deviate and why that would be a reasonable thing for you to do. The third in the done is, if a person charged with negligence defends his conduct by establishing that he followed the practice which was general and approved by the colleagues of similar specialisation and skill, he cannot escape liability if in reply the plaintiff establish that the practice has inherent defects. So if you are operating and the protocol and the practice within your lab or within law or within any field of a professional skill or any profession, if the practice is defective and you're sitting there thinking this isn't good enough, this isn't, that if you have thought that, then the fact that it is the general practice will not be sufficient. We have an obligation to point out defects in practice while we're practicing. Right? While we can deviate, at the same time, if we're doing something and it's poor practice, then there's no excuse for that. That will not be forgiven, and we can't pull down the cover of, well, this is what everybody does in our lab, in our hospital, in our whatever. So we've got to, if there are flaws, inherent flaws, then that will be not sufficient to evade liability. And then the last one is, or the second last one is to say, it's okay for two practitioners to be different. It's okay for them to have an honest difference in treatment. That is perfectly reasonable, as long as both of them can stand over it. So I might not agree that, whatever, it should have been sent off, or this particular course of antibiotics should have been given. I may not agree, but if it was a reasonable thing for them to do, it's okay for different medical practitioners to have a different view. And that won't be adjudicated to negligence. So there is a lot of cover, and there is a lot of latitude. At the same time, there is a responsibility to ensure that we are operating at best practice standards all of the time, and that we're not just following a protocol just because it's there. We've got to interrogate the protocol for it being best practice. So there's an implication in law that we will do that in order to avoid negligence, we will always be interrogating why we do things the way we do, and is it the best way that we're doing it. So that's on before Ruth Morrissey's case. And then the last is does it comply with a peer review? If an equivalent specialist were to look at something, would it comply? Okay. And then we come down to, Mr. Justice Cross noted that the tests in Ireland are all down to, it's all surgical, surgical moments of a decision by a consultant at a particular moment, and that then goes disastrously wrong. And in Dunn's case, it was around the birth of a child. And then subsequent cases, that's where. But he acknowledged in the Morrissey hearing, in the case, he said, allowing for the fact that Dunn seems to be given particular deference to surgeons operating in hospitals, it still is the standard, and it is the test that will be applied to laboratory scientists. Okay, so this is the test that applies to you. And lastly, before we move on to the actual Morrissey case, we look at the fact that there is an obligation in contracts for it to be the best laboratory practice is being adhered to. And in the HSE contract with Quest and with MedLab, there was an obligation within it, and the clause from the contract is the exercise of that degree of skill, diligence, prudence and operating practice which will be considered as good practice from a skilled and experienced laboratory of a similar scale and profession standing engaged in the provision of cervical cytology, screening and related services. Okay, so there is an expectation of the best of skill. So maybe they're considerations. The reason that we have whistleblowing legislation and protected disclosure legislation that is effective from day one of people going into work. So it's not, if you're dismissed for whistleblowing, you have the protection of the law from day one of your new job, whereas in normal unfair dismissals you have to wait for 2 years. The reason for that is because people fresh out of college aren't in the culture of a particular place. If we take Drogheda Hospital or Our Lady of Lourdes, and the observations of a very junior member of staff there that challenged why isn't Evan doing things the way he's doing it, and that there are people who go in with fresh eyes, with the and the optimism of fresh arrival. They're not indoctrinated into culture of a particular facility, and consequently they're more likely to see where something erroneous is occurring and something highly negligent is occurring. And so we have those protections from day one. So that's worth remembering, when it comes to the protocols, slipping, having your observation, valuing, regardless of valuing your observations. Sorry, that's me straying into another area of law.